This is News 12 Law Call.
Hi there. Welcome to News 12 Law Call Zoom edition. As we zoom through the holidays, we're here to try to keep you safe out and about at retail shops and big box stores and such. Slips, trips, and falls can be pretty prevalent this time of the year. We are blessed to have on the founder of the Hawk Law Group, Vic Hawk, and his partner, Reed Sanders. And I guess it's not too early to say happy holidays.
Yeah, everybody's getting started on our street. I probably have half the houses have their Christmas ornaments up.
Yeah, I mean, I was doing honeydew Christmas lists, I think, the day after Halloween. So
Good gracious.
Oh, yeah. Is this the type of thing that you deal with at the Hawk Law Group? Do people call you and say, "Oh, I hurt my back. I was at the store," and how's it go?
Well, they call us and they tell us what's happened to them, and then we try to give the free advice to let them know what they should do following something like that. Sometimes it's really minor, and then sometimes it's very serious. Reed has developed an expertise in slips, trips, and falls, and he hears some stories.
yeah,
Well,
that's true.
all right. He gave you the entree. Reed, anything come to mind either at a store where you represented a client, or does this sort of thing happen maybe out in the public or even near your home?
I mean, honestly, it's all about liability and what you can prove. But I've had cases outside. I've had cases in stores. I've had cases in homes. I've had cases in restaurants and Dollywood. So if you name
Wow.
it, there has been a premise liability case that I've at least looked at.
Okay, makes good sense. Well, we have several lively questions tonight for the both of you, and whoever wants to jump in on this, feel free. This one comes from Daryl. And this is kind of a preventative question, I guess. If he's in a slip, trip, or fall accident, what's kind of the next step as far as finding out whether it is something that you could pursue as a legal claim?
Reed, you go ahead.
Sure. So the first thing that you got to do is serve notice or protect the claim. And what I mean by that is there's things that you have to tell the at-fault party so they can't destroy the evidence. And sometimes they do it intentionally. Sometimes it's just done over a period. If they have a recording, that the recording stops or starts over after a certain period of time. So you want to give them notice and protect that claim. And then secondly, you got to figure out what your damages are. There's a lot of cases where you have a small injury, maybe a twisted ankle, or just some bruises and bumps. And there's different ways to handle that. There may be med pay, which is a store may have payments of medical bills regardless of fault. So if you have very limited damages, there may be different avenues. Whereas if you have $100,000 in medical bills, well, then it's going to be a much more difficult case. And obviously the stakes are a lot higher in that regard.
Okay. This time of year, a lot of holiday parties, and Daniel's questions kind of related to being out and about at a friend's house. And he was at a party and just slipped coming down some stairs. And if I can recall, that happened to a Masters golfer a few years ago, now that I think about it.
That's
I
right.
Can't remember which golfer, but it's pretty prevalent. As far as Daniel, his ankle will need surgery, but he just doesn't know because it's his friend. Should he ask his friend's insurance company to pay for the medical bills?
Daniel, it's not unusual that something like that were to occur. The reason that we say these types of cases are difficult to handle, and many lawyers just don't do it, is your status at the home is going to play a huge role in the burden of proof that you have. And if you're just a social guest, you have to show that the homeowner engaged in willful and wanton conduct leading to your injury, or intentional conduct. And if you just slip on the stairwell, that just does not establish a basis for liability. But just like Reed mentioned a few minutes ago, all these homeowners policies have at least some limited med pay. In other words, regardless of fault, if you're injured on the premises, that med pay will cover those medical bills up to a certain limit. I've seen those limits as low as $500 and as high as $20,000. So there's nothing wrong with contacting your friend to see if there's some med pay to cover those medical bills.
Okay. Emma's concern happened at an area grocery store. She was in the grocery store aisle. She hurt her elbow. She thought there was a wet spot. She did not see one of those yellow caution signs. What should she do besides call you?
So, I mean, yeah, the first thing that an attorney would do is, like I said, preserve the evidence and send a spoliation letter. And that's a fancy word for just saying, hey, y'all can't get rid of anything. And the next thing to really think about is who has notice of this hazard, right? So just because there's water on the floor and just because you slip in it doesn't necessarily mean that you can recover. You have to show that the store either did have knowledge or should have had knowledge. And you do that by looking at their inspection timing. How long had the water been on the floor? A kid could have come by and knocked over some water 3 seconds before you slipped on the floor. And if that's the case, then the child would be liable. But obviously you're not going to sue the child and be able to recover. So you have to show that the store did something that they should not have done. And by doing that or trying to do that is very difficult. And so that's the first thing to do, is to make sure the evidence is preserved and get the spoliation letter out.
I want to add something here. Rita's pointed out that we send out a spoliation letter. The letter is designed to preserve evidence. And most of these stores have video. And I'll tell you a quick story. One of the cases that came into our office, a lady had broken her ankle when she slipped on a grape in a grocery store. We sent out the letter asking them to recover and hold the video of what occurred. Well, it saved an awful lot of litigation, an awful lot of trouble and expense when the store sent us the video that showed on the aisle next to where the lady fell, a little boy was throwing grapes up in the air and trying to catch them. He missed. And the grape just so happened, hit the floor, rolled under the shelf, over right into the path of this lady that slipped and fell. The store didn't have sufficient time to have notice of the grape being on the floor. Reasonable inspection procedure didn't apply, and so there was no liability. So all we did was get the med pay for the client to get some of the medical bills paid. And we didn't go to the trouble and expense of doing a personal injury case that was completely unnecessary. So those spoliation letters that we send out are very, very important, both for you or could be against you, but that's the truth of what occurred.
Right.
So what happens when you get hurt at a church or maybe even an apartment complex, a theater? We'll examine those issues and take your questions again on the other side of the break. Slips, trips, and falls here on News 12 Law Call.
Welcome back to News 12 Law Call with award-winning broadcaster Neil Gordon. And from the Hawk Law Group, attorney Vic Hawk, with more than 30 years experience and millions of dollars awarded to his clients. Attorney Reed Sanders, born and raised in Thompson and known for his strong courtroom skills. With criminal law, former police officer, now lawyer Sean Merzlach. And with South Carolina injury law, trial attorney Chase Hawk. Plus guest attorneys from across the CSRA. Your rights, your calls, live. News 12 Law Call.
Welcome back to News 12 Law Call Zoom edition. I'm Neil Gordon, and we're discussing slips, trips, and falls on this latest edition with a few of the partners of the Hawk Law Group, Vic Hawk, the founder, and Reed Sanders. And hello, gentlemen.
How's it going?
Hello, Neil.
Well,
it's good to see you again.
Well, it is good to see you as well. I'm glad you're doing well. As we discuss this, we're still dealing with COVID issues, but here and there, some theaters have been open in parts of the community and in the Southeast and such. And Izzy has a question about this. Apparently, Izzy's wife and he were leaving a theater a few weeks ago. She slipped on one of those aisle carpets, fell forward, hit her head on a corner of a seat, had some medical attention. Just wanted to know if maybe the theater would be liable to pay any medical bills or if there are any other damages.
Well, I'll start it off. So the answer to that is a good lawyer answer is maybe. So it's all about, like we talked about prior, it's all about liability and what you can show. Now, in this specific instance, we would have to look at when she was leaving. Was the movie over? Was it during the movie? Was she using the bathroom break? And then you got to look at the lighting situation. Let's say the movie was over and the lights came on, but the lights didn't come on and she fell because she couldn't see. Well, then the theater's probably liable. If it's during the movie and she's leaving and trips, the theater's probably not liable. One issue is also that if there's something wrong with the carpet, well, she passed over this carpet going into the movie. So once you've traversed something, it's very, very difficult to say that you did not know about a hazard because you've already crossed it. So that turns into assumption of the risk. Now, in this case, if they're limited medical bills, like we've talked about and Vic talked about prior, you could have med pay, and a theater will have med pay because there's certain claims that are going to be very small that they don't want to have to fight over who's at fault. So once again, it's get the notices out, get your spoliation letters out, find out the extent of your medical damages, and then there may be a situation where you can get med pay to pay for those medical bills.
We have a case in the office now where I don't know if y'all can hear that. My dogs are the alarm for the doorbell. Anyway, the case came in where the guy watched the movie. The movie ended. It was still dark as you adjust the lights as you're leaving. But the problem was it was one of these lounge theaters where the seats lay back and you had the footrest sticking out. And he tripped over a footrest, and when he did that, he broke his hip. Well, what we found out was the movie theater had turned off the automatic feature of their seats, that as soon as the movie was over, the seats were supposed to adjust to the upright position right away, automatically. And so there was a basis for liability arising there, where the lights are very dim, the movie is over, and they have a mechanism to adjust the seats back to the upright position, but they just turned it off. And so whoever last sat in that seat didn't put the seat back in the upright position, and the theater could be held liable under circumstances like that. And just like Reed is talking about, it depends on the circumstances of the case, and you have to evaluate every aspect of it.
And Vic, if you'll ask your friends to come back in a few weeks, I think we have a dog bite episode coming up.
That's workers showing up at the house, and
Well, I mean, that just shows the great concentration. That shows the great concentration of my man, Mr. Hawk. There, just fired right through it. Dog's going crazy,
Laser focused. I love it. Reed, the next one's for you from Jemiah. This has to do with government situations. He just wants to know if the city officials would be responsible for medical bills if you trip and fall. Like, let's just take Broad Street, for example. You're walking down Broad Street grabbing some lunch, and there's faulty sidewalk that maybe should have been repaired. Do you have any kind of claim, or are they, what's the term? Are they indemnified from this?
There can be some indemnity, but really what you want to look at is the extent of the hazard. So when you have a slip and fall or premises liability case that is outside, it's much more difficult, because as you're walking outside, you're supposed to have a heightened sense of awareness. So if there is a change in elevation inside a store or inside a business, that you don't expect that. But if you're outside, you should expect some kind of change in elevation of the sidewalk. Now, that doesn't mean that it can be a huge hole or an optical illusion. We've had cases where the sidewalk ends and then starts again, and in between the two is the exact same color, but there's a 5-inch drop. Well, if that's the case, then then the city could be liable. Also, you have to look at, has there been prior falls in that area? Does the city know about this and they know that there's a problem and they will not correct it or will not fix it? We've had cases where you can go back on Google Maps and look 2-3 years back and there's still a hole in the ground. And they say, well, we didn't know about it. Well, it's been there for 3 years. Then you have some recourse. But anytime you have an outside case, it's going to be more difficult. And especially if it's against a city, a county, a state, whatever, because there are indemnity issues that you got to get around.
And let me add something there. With regard to cities, there is a basis for liability just along the lines that Reed just described for you. And when you go into counties have qualified immunity, and it is very, very difficult to establish liability of a county or a state agency under circumstances involved with a slip and fall. We just finished 2 years of litigation with a county in a similar case where there was a change in elevation in the sidewalk. And what we had to deal with was their qualified immunity. We had to show that they had notice of the difference in the elevation and that their failure to act was ministerial. The Georgia courts have basically never found any of the acts of a county to be ministerial. So as a result, they have immunity from suits filed against the county. So it's very important to know whether or not this was a fall that occurred on county property or city property. County property had a real huge mountain to climb.
Great anecdote there, Vic. And when we come back, we'll talk a little bit about skating rinks. During the holidays, we generally have a pop-up outdoor skating rink, and there's been indoor ones across Georgia and South Carolina. We'll try to solve an issue when we come back. You're watching News 12 Law Call. We'll see you in just a few minutes. Thanks to the partners of the Hawk Law Group for appearing tonight. By the way, their 4 offices are open, plenty of social distancing. If you want to make an appointment by calling all 4s with a 706 area code for a live chat or helpful resources, their website is hawklawgroup.com. And Vic and Reed are back with us, and we're going to close the program with a couple of places that folks can slip and fall. We'll start with a church, and Blake said he fell down some stairs of a local church, hurt his arm. It was back about 6 weeks ago, the arm just beginning to give him problems, and he just wanted to know if there's a statute of limitations for filing a claim.
Blake, the statute of limitations is 2 years from the date of your fall. And it's very important that if you assert a claim that you make that filing in the court. So it's a hard, fast line that you cannot cross. When you do cross it, it's too late to assert your claim. But it's generally, the rule is from the date that you fell and injured yourself.
And one thing I think people have confusion about, Vic, that I run into a good bit, is that doesn't mean that your case has to be finished, and it's very likely that your case will not be finished by the end of the statute or the statute of limitations. That just means your case has to be filed. So you can have a case that's 6, 7, 8 years old, potentially. Some of these, higher level cases that just can't get wrapped up very quickly because you don't know the damages. Those things can take a long time. So the statute of limitations is just in regard to getting it filed, not for the completion of the case.
Okay, and our last question before we scoot, is it a case of kids will be kids or some liability for parents? As Trina and her family was at a skating rink and a child that they did not know shoved her child, causing her child to break a tooth. Anyone responsible for the dental bills?
The easiest answer is no. So I guess potentially could be if you'd have to show that the owners of the rink knew that this child was a danger and they didn't remove this child, which is going to be almost impossible. So yes, you do have a recovery against the child. You may have a recovery against the children's parents, but in most likelihood, it's not going to be worth going down that road. It's going to be one of those, an accident happened and kids will be kids kind of thing. Like I said, the only other issue there, if it's a broken tooth that can be fixed very quickly, then you could have med pay. Once again, if it's a small injury or small damages, regardless of fault, med pay can still be available.
Reed is exactly right on that assessment. We keep talking to y'all about phone calls where you're discussing injuries or fault, and of course the advice is free. We're happy to talk with you about the circumstances of your case, but you have to understand that if you get involved in litigation, it can be very expensive. Just to even file a lawsuit, it costs about $250. Then you'll need to, in the case of the broken tooth, you would need to take the deposition of the child that pushed. You need to take the deposition of the parents. You need to take depositions of the employees at the skating rink, as well as depositions of the dentist. So those costs can easily run up to $5,000, $6,000, $7,000 in a case. So be aware that every case, even if there's liability, is not a claim that you should file in court because it is very expensive to pursue. Now, we advance costs in cases where it is worth pursuing.
Well, thanks, Vic, and thanks, Rick. Thanks, Reed.
Yeah, Rick too.
Yeah, it's been a good half hour. I think I'm just going to go over and walk Vic's dogs.
That'll be
Everything
great.
will be great. Have a great week ahead and holiday season as well.
Thanks, guys.
Thank you for staying up with us.